So my topic is the theoretical starting points for relating global ethic to law and policy. I think this raises and constitutes an illuminating and a provocative undertaking at the same time, both. Illuminating because each side has something to offer to the other, taking law and policy as kind of a combined group. Provocative because each poses something of a challenge to the other. The global ethic questions the assumptions behind conventional notions of law and policy, particularly positivist versions of law as a social fact, nothing more, nothing less. Look it up in the book, and that's what it is. The global ethic does this because at least in spite of what Alistair McIntyre called, quote, the state of grave disorder in ethical language, in which, quote, there seems to be no rational way of securing moral agreement in our culture. He said that 25 years ago. The global ethic, I think, is peculiarly well situated to ask law what its moral basis is. Now, further problem, though, for entering this discussion is that it seems to me that many legal theoreticians are reluctant in general to talk about religion, at least outside of the constitutional context of establishment of religion, at least in this country. The late Harold Berman referred to, quote, the almost wholly secularized Western legal culture. I would add that it's not only secularized, but it's also in many quarters resistant to ethical questions of a general nature, particularly regarding justice. When I was a student at Harvard Divinity School, I see one of my fellow classmates there, there was a story that circulated about the law school to the effect that a law professor told a law student who raised an impolitic question, if you want to talk about justice, go over to the divinity school. So what I want to suggest is that the global ethic can, in fact, in spite of these challenges, deepen conventional understandings of law and help it to achieve a fuller vision of justice. So for its part, law and modes of legal reasoning, particularly the process of the explication and development of constitutional norms, can profitably contribute to the further articulation of the global ethic. That would help address one of the persistent criticisms that I've encountered in my reading of the global ethic, namely that it's a minimalist formulation. So for some critics, this means more or less that it's useless and irrelevant. So this criticism, I think, is a bit surprising because Hans Küng acknowledged the global ethic's minimalistic character early on, but did not consider it a detriment. And I believe in his handling of it, it is not. But the charge, behind the charge of minimalism is the further assumption that the global ethic is an unchanging, static, fixed document, if you will. I think this attack loses force when the global ethic is viewed instead as an evolutionary project, capable of and indeed inviting further development. Another criticism is that the fundamental ethical directives of the global ethic are hopelessly abstract. Now, they are indeed general. If you pick up the Declaration from 1993, that's immediately obvious. But you know, the same is true of constitutional norms. In the US Constitution, there are generalized rights such as free speech, assembly, and due process. In the German Basic Law, there's the right to personal development. Well, just what does a concept like personal development mean? Is it to be understood in material terms, psychological, spiritual terms? If the latter, what role does the state have to play in that right? My point is just that the words themselves help little in answering these questions. It's through the process of the incremental interpretation that supplies their parameters and content. The same can and has happened with the global ethic. Of course, the parallels between a constitution and the global ethic are imperfect. An ethic has traditions and classics to draw upon, not binding precedents. Law has authoritative decision makers and interpreters in the persons of judges and hierarchical decision makers, and authorities for the review and revision of judgments, while an ethic does not. Law has procedures for establishing rules about the form and content of acceptable arguments and requires them to be guided by statute and case law. This, of course, is not true for an ethic. But these differences notwithstanding, the fundamental interpretive process in both law and ethics is analogous. In fact, one prominent scholar of U.S. constitutional interpretation, Philip Bobbitt, specifically identified ethos as one of the 6 modalities of constitutional interpretation. So I'm suggesting here that the relation between the global ethic and law is reciprocal. Both can learn and profit from each other. So I want to propose generally that the global ethic is both a document and a process. I want to argue that its open-endedness, its provisionality is not incidental but necessary. After all, the global ethic derived from religious traditions that are vital evolutionary phenomena. Ethical understandings and conceptualizations can and do evolve over time, reflecting the experiences of human beings as they are transformed by the pressures of changing economic, technical, geographic, and cultural circumstances. The dynamic evolutionary process in the Abrahamic religions has been described and analyzed by Hans Küng in his trilogy on Judaism, Christianity, and Islam, collectively comprising his project entitled The Religious Situation of Our Time. Now, given the vast changes in each of these, indeed all traditions, it stands to reason that our understanding of the underlying ethical wisdom they contain has evolved and will continue to evolve. And our grasp of the global ethic can be deepened through interaction with diverse fields of activity and other disciplines. Stephan just mentioned several of those. So I suggest that the interaction between the global ethic and its applications can be enhanced by expanding and deepening encounter with law. A second general point I'd like to suggest is that there's much in favor of a conversation between the global ethic and law and policy because each of these domains is concerned with justice. Other spheres wrestle with justice as well, of course, economics, politics, but in law, justice is a fundamental concern. Admittedly, the relationship between ethics and law is rather complex. In fact, the fact remains that each is indispensable for the other. As Hans Küng expressed it, quote, "The level of justice is as necessary as that of ethics. Both mutually support each other without allowing the one to ignore or be absorbed by the other." I'd now like to turn to a couple of schools of thought within the fields of law and policy and use them as sort of case studies for the interaction of the global ethic and law. In particular, I want to consider questions of jurisprudential theory and practice and a couple of theoretical aspects of public policy and privately sponsored policy. My intent is not to dissect these theories or schools of thought or even to give an adequate account of them. Rather, it's just to identify an aspect or two of each of them that seem to me to be particularly poignant for the global ethic project. But before proceeding further, I want to make just a distinction between a global ethic and the global ethic. There have been other attempts than Hans Küng's to formulate a global ethic. I'm not going to be concerned with them here. I'm going to concentrate on Hans Küng's version as set out in the 1993 Declaration. And as I suggested a minute ago, we shouldn't take this as the last word because, of course, it was followed by other documents, also from the desk of Hans Küng himself, such as the recommendation of the Interaction Council for a General Declaration of Human Responsibilities, 1997, the Manifest for a Global Economic Ethic, 2009. Stephan mentioned these. So I'm taking this as a general concept for Hans Küng's work on the global ethic over an extended period of time. Now, I want to note at the outset that Hans Küng himself has drawn a rather sharp distinction between the global ethic and law. For example, he writes in the commentary on the Declaration toward a Global Ethic, programmatically, such a declaration must penetrate to a deeper ethical level, the level binding values, irrevocable criteria, and inner basic attitudes, and not remain stuck at the legal level of laws, codified rights, and paragraphs with which issue might be taken, unquote. So contemporary legal theory is generally organized in a basic typology with positivism on one end and natural law on the other. Between them and a vast middle ground, there are various schools such as legal realism, sociology of law, anthropology of law, Scandinavian realism, outsider jurisprudence, and so on. What I'd like to look at today in particular is the interpretive theory of Ronald Dworkin, the American legal philosopher who spent much of his career in England. He's credited by many critics as having developed a third way between positivism and natural law, although pick up any reference book and you're as likely to see him classified with the natural law theorists as in any third category. Now, according to this theory, it is one that, quote, interprets rather than simply describes or judges legal history. It aims to reformulate past legal decisions in the most coherent and morally attractive way consistent with the facts of legal history, that is, with the words past legislatures used, the concrete orders past judges actually made, and the political and moral traditions of the community. Close quote. Dworkin contends that neither positivism nor natural law reflects the actual practices of judges. Contrary to the claims of positivists, judges do offer moral arguments about what the law is, where it's unclear or undeveloped on a given point. And in contrast to natural law, there's no gap between what the law is and what it should be. Dworkin's theory is, if anything, constructive. It aims, he writes, quote, to reformulate past legal decisions in the most coherent and morally attractive way, consistent with the facts of legal history. That is, with the words of past legislatures, concrete orders of past judges, and moral traditions of the community. This comprehensive process is summed up in Dworkin's idea of law as integrity. It is integral through its coherence with past and the present, and its consonance with communal, political, and moral aspirations. Dworkin claims that jurisprudential issues are at their core issues of moral principle. So for him, law and morality, in fact, hang together inescapably. Although they do hang together, they are subject, in his theory, at least morality is, to two limitations. First of all, the morality relevant for law is of a particular kind. It's the morality of judges and lawmakers as they determine it, consulting in consultation with the communal moral content in legislation and adjudication. So this gives Dworkin's theory a pretty communitarian cast. A moral reading of law for Dworkin, quote, is one that asks judges to find the best conception of constitutional moral principles, the best understanding of what equal moral status for men and women really requires, close quote. So how can the global ethic relate to this theory of law? By positing a certain common ground extending across diverse religious traditions, the global ethic suggests that even pluralistic communities can and do, in fact, share certain fundamental moral commitments. These commitments can be consulted in a judicially and procedurally appropriate way through the development of law. Now, one of the weaknesses ascribed to Dworkin's theory is that he has a relatively isolated notion of a community. Now, granted, he's talking about political communities primarily, and they do have, of course, definite legal boundaries, but even political communities are not impervious to external pressures such as immigration, cross-border economic flows, transnational environmental impacts, and of course, cultural trends. The cohesiveness of community is sustained not only by a common vision of justice, rights, and law, but also by other values, among them tolerance, a certain degree of economic fairness, legitimacy of its institutions, and personal integrity of individual community members and leaders. Now, looking to the global ethic, one of the 4 directives concerns tolerance. Traditionally, tolerance is not a distinct legal norm in and of itself, but is implicit in other fundamental rights, such as the necessary limitation of those rights for the protection of others. Both American and German constitutional jurisprudence recognizes the right of freedom of speech, for example, but it's not an unbounded right. So viewed implicitly, tolerance can be overshadowed by robust claims of personal freedoms. A community needs, however, an affirmative sense of tolerance, one that promotes it as an intrinsically valuable right and duty. Now, I'm not contending that tolerance or any other element of the global ethic is immediately translatable into legal norms. Dworkin, for one, would likely view that as an intrusion of external rather than what he calls embedded morality into the province of law. Hans Küng's original distinction between law and the global ethic is well-founded and should be respected. But the law, in Dworkin's sense of a comprehensive body of social rules tending to the progressive realization of justice, can, I believe, benefit from the broad moral resources of the global ethic. It embraces many of the same concerns of law and justice: a just economic order, humane treatment of each person, and gender equality. I might add that the global ethic can also learn from law and legal reasoning, as I've already suggested. Like a constitution, the global ethic contains general norms resting on basic values. They are capable of conflicting with each other in given circumstances, but also of cohering with each other as developed through an interpretive process. The process of achieving coherence is essential for the process of achieving community. Dworkin puts this very nicely in the following quote: "Every contemporary democracy is a divided nation, and our democracy is particularly divided. We are divided culturally, ethnically, politically, and morally. we nevertheless aspire to live together as equals. We cannot pursue that indispensable ambition unless we undertake, when necessary, to ascend high enough in our collective deliberations, including our adjudicative deliberations, to test our progress in that direction. We must undertake that sovereign duty if we claim a rule of law that is not just an instrument for economic achievement and social peace, but an emblem and mirror of the equal public regard that entitles us to claim community. Close quote. I want to now turn to another area of legal theory that in ways stands in rather sharp contrast to Dworkin's interpretive theory, namely the cosmopolitan theory of law. Cosmopolitanism is concerned with defining the moral duty each of us owes to all of us. It asks the question whether political association is in fact a necessary condition for law. For example, a person may be accused of crimes and prosecuted perhaps under a theory of universal jurisdiction by any country. Is that legally permissible, even in countries where the person has no contact? Or do people have fundamental, legally cognizable entitlements, regardless of where on the earth they may have been born? Traditional legal theory holds that law and the government coercion used to enforce it is exclusively a prerogative of political associations. Cosmopolitanism, in contrast, particularly in the version articulated by Noah Feldman, quote, generally directs our attention away from political associations like states as relevant makers of moral categories. By treating the individual as primary and his or her political associations as secondary, cosmopolitan theory can clear the way for imagining not only moral and ethical, but also legal duties justifiably arising outside of the bounds of state or other political power. I'm now going to jump, because of the warning I just received. Cosmopolitanism and the global ethic seem to share certain affinities. Hans Küng speaks of the humanum. While cosmopolitan theorists may or may not use that term, both global ethicists and cosmopolitans affirm humanity as a core idea. And both would appear to stand at a distance from law and legal obligation, but as I've already suggested, there are reasonable grounds for the view that the global ethic can, in fact, contribute to the strengthening of the moral foundation of law, relating back to my comments about Dworkin's theory, particularly in pluralistic, divided societies. And I think it can assist cosmopolitan thought, by way of comparison, in striking a balance between universal and local obligations. So looking back, they're perhaps not so unconnected, after all, the jurisprudential theory of interpretism and cosmopolitan theory, the one directed toward discrete communities and domestic law, the other to the global community, toward transnational law. They're complementary and supplementary to each other. The global ethic can contribute to each through its affirmation of the common within the diverse, and the diverse as the manifestation of the common. So in conclusion, certain themes seem to recur. The inseparability of ethics from other fields of knowledge and activity, the tension between political legal communities and the broader global community, between segmented notions of duty and general obligations. In light of these themes, and with special reference to the global ethic, the following seems to me to be a set of reasonable starting points. 1, an adequate vision of law must have a moral dimension. The global ethic can contribute to a broad understanding of justice, or broadened understanding of justice, and to the formation and maintenance of the moral identity of societies by affirming the possibility of consensus based on moral imperatives, even under pluralistic circumstances. 2, policy as the formulation of principles and strategies to address problems and achieve goals by establishing prescriptive courses of action needs moral guidance to prevent it from becoming purely instrumental. Private sector policies, so-called regulation by privatization, concerning social responsibility must avoid being co-opted by bias and self-interest. Public sector policies must balance their concerns for the collective good with the undue disadvantaging of individual persons through the denial of basic human treatment. 3, each of the domains of the global ethic, law, and policy has a distinct vocabulary and methodology, yet they evidence collectively a concern for the conditions of justice, or rather that each of them have that capacity. Each has something to contribute to the development of that capacity. Are these points general and abstract? Obviously. They're starting points, not ending points, and I hope that during the course of the symposium, they might provide a framework for our discussions and through that gain further substance as the dialogue moves forward. Thank you.
Thank you very much, Bradley, for this excellent introduction. Right from the beginning, you said that global ethic and law, this is a reciprocal relation and both can learn from each other. And I think you gave us a brilliant illustration of this thesis that is really the very reason of our symposium, the conviction that each of the three, in fact, of global ethic, law, and policy can learn from each other. And what we shall try to do these 2 days is to explore ways of this kind of cross-fertilization of these three elements. Thank you very much indeed. Now I am most happy to call upon Professor Hans Küng, our dear president of the Global Ethic Foundation, for his lecture on global ethic and global law, philosophical aspects. There is really no need to introduce you, Hans Küng, and I would just mention that you were given 10 more minutes for your presentation, so 30 minutes, and I would like you to take the floor, please.
Dear colleagues, dear friends, already yesterday evening I told you global ethic is not a utopia which resides nowhere, but it's a realistic vision which, of course, is already in the process of realization. It's also a very realistic program. It's a program of hope, but of course also a program of criticism. And I think you have to read only the newspaper every day, and you find enough occasions to use ethical standards to judge about all that. Last week, I read an article in the New York Times about the Citigroup, the biggest American bank. It was said that this article that Goldman Sachs mortgage traders look like Boy Scouts in settling its fraud charges for $550 million last year. The news was that the Citigroup had to pay 385 million fine to settle a case in which, on one hand, Citigroup sold a package of toxic mortgages backed in securities and in circumspection contents. Really, the light is very bad here. My eyes are very bad too. They sold the securities. On one hand, Citibank had a package of mortgage backed securities in suspecting customers, to circumspecting customers. And on the other hand, they shorted the same securities, that is, bet millions of dollars that they would go bust. It doesn't get any more immoral than this. It doesn't get more immoral than this. That's only one of the very numerous examples where you are asking, is this not only the lack of morality in the bank, or in certain executives, or in certain also organs of supervisory organs, and why is it not the moral aspect also discussed? It's only the legal aspect discussed. In earlier times, the United States showed a great deal of honesty. We often considered American democracy and also the legal system better than many things in Europe. But what we see here as scandals, we had several of this kind in Wall Street. We had similar scandals in public policy, in foreign policy, in the context of the Iraq War, etc., etc. So you see, all this is not only, these are not only legal problems, but also moral problems, not only problems of the institution, but also problems of the people involved. I think it's important to see first law and ethics that these are two different dimensions. As all of you know, of course, are well aware, there is a difference between the dimensions of law and ethical behavior. The legal dimension is seen as a domain of laws and regulations, of adjudication, and of course of legal studies and jurisprudence. In this legal dimension, the direct analysis of legal rights and their enforcement is possible and often necessary. Legal enforcement. External sanctions of various kinds are available, as that the legal rights can be asserted and enforced. In contrast, endorsement of or coercion at the level of ethics is not possible. The dimension of morality, of morals or customs, of ethical behavior lies at the level of conscience. In other cultures, the realm of the heart, or after Immanuel Kant, it's the inner court of justice. The words ethos and ethic are often used interchangeably, but in practice they should rather remain separate. Ethos in English, ethic without an S. Ethic means ethical, moral behavior, moral conviction. The term ethics, ethic, refers to a field of science that deals with the development of philosophical and theological ethics. In English, ethics with S is understood primarily as a teaching or a system of ethics. Of course, both levels have something to do with one another. I do not share the opinion of legal positivists who want to divide law from ethics, behavior completely. Such positivism rejects every necessary and often every dependent connection between law and ethic. Today, in contrast, many lawyers reject this view, and rightly so, with the acceptance of formal criteria related to the formation of laws, the implementation of laws, and the effect of laws, the question of an ethical justification, the justification for the content of substance of the law has not at all been resolved. The unjust laws passed under National Socialism and Communism clearly showed the devastating consequences of such legal positivism. A recent counterexample is one offered by the Obama administration, which has begun to correct the many legal manipulations of the previous Bush administration. Particularly the Department of Justice in its departments of justice officials, and which raised the use a question of moral criteria in the making and interpretation of laws in the United States and in the rest of the world. But if I'm not a legal positivist, I'm also not one of the natural law philosophers who believe that law and ethics stand in direct relationship to one another, and that all positive statutory law is based on natural law. There is, of course, a great deal of truth in natural law. Nevertheless, the natural law consists of basic principles that independent of human consent and human-generated positive law would always remain in force. That is the pretension. But these principles themselves should be established. It is very difficult to establish these principles within the nature of things, or from a priori defined a nature of human beings. We prefer today to speak of persons and not so much of nature. Since Immanuel Kant, a sharp distinction had been drawn between morality and law. As a theologian, I cannot understand why the natural world, the nature of human beings, should contain within itself a criterion or measure for determining what is morally right. So, for example, the question regarding what a naturally derived morality would be in terms of sexual or social relations would seemingly be easier to answer. But precisely this question elicits very different answers. With regard to content, the terms nature and law are seen quite differently, so that the concept of natural law has proven itself to be easily instrumentalized, even subject to manipulation. An example for how disastrous the deduction of moral precepts or commands can be is the ban against contraception issued by Pope Paul VI in the encyclical Humane Vitae, apparently because it is against the law of nature. Law and ethical behavior also cannot be completely separated as illegal positivism, or being directly related as in the teaching of natural law. I myself argue for an indirect relationship, and such a relationship should also replace the so-called interpretive conception of legal concerning. I think I agree greatly with what Bradley said about Ronald Dworkin's vision in his book Law's Empire. But I would not like to go better in. I think we need this middle way between the natural law and the legal positivism. Now, the second question is, what is Weltrecht, global law? what I understand as global law is neither a utopian global state nor a future global constitution that as new legal entity would supersede all existing laws, regional and national constitutions. Rather, what I really mean is existing international law and transnational law, including legal enactments of global institutions. That's a very encompassing concept of global law. It means the existing international law and transnational law, including legal enactments of global institutions, UN, etc. Generally, jurisprudence makes the distinction among the three sources of public international law: contract law or treaty law, common law or customary law, and general legal principles. First, international law, international treaty law, meant here is the positive statutory law as set down in formal international treaties and conventions. That is, it is a law generated through a legislative process that has a rational and technical advantage as a result of the specificity of its provisions. But international law, for quite some time, managed to get along without laws institutionally generated by states, because it was based above all on customary international law. And that is the second source of international law. International customary law or common law is rooted in the generally binding practices of states and created by a continuous, steady exercise supported by the legal convictions formed within a legal community, hence the term customary law. At the time when there was no written law, or at least only a handful of individuals who could read and write, such customary law was generated and conveyed through this actual exercise. Compared with international treaty law, customary law has a great advantage in that it has been preserved through long and ongoing experience and refined through reflection. It could thus largely keep itself distant from and free of the strong influence of individual states and from one-sidedness combined with it. International customary law carries on this great tradition and legacy, and this also highlights the relationship between legal regulations and prohibitions on one side and moral responsibility on the other. However, the interrelationship becomes more evident through the inclusion of a further source of international law, and that is the third. The third source is general legal principles. According to Article 38, Paragraph 1 of the Statute of the International Court of Justice, the general international principles of law constitute the third legal source for international law or Völkerrecht, after international conventions and customary international law. The extent to which these general international legal principles are compulsory, that means binding, is debatable, including whether they have the same compulsory status or treaty laws or customary laws, as treaty laws and customary laws. Even if one did not recognize their binding obligation, this principle nevertheless can exert a great degree of influence on the international legal system. They can even reflect a self-producing consensus over fundamental principles, a consensus that can mature into a legal norm. A consensus exists among jurists that certain general legal principles are essential for the functioning of every legal system. Of course, it would help tremendously with the task of implementing general legal principles into law if a consensus among jurists could be achieved that the implementation of general legal principles through an ethos is necessary. My conviction is without an ethical foundation, the implementation of these principles of law from the very outset would be rendered questionable. How does this look applied in the real world in practice? I come to the third part, global ethics and law in practice. Despite and in part because of globalization, today we live in a politically and religiously divided time that is marked as much by the presence of widespread war and conflict as by general absence of direction and orientation. I'm not a cultural pessimist, but with all of the positive development that has occurred, we can point to one thing that cannot be ignored. We live in a time in which many moral authorities have lost their credibility. We live in a time in which many state, cultural, and unfortunately religious institutions are increasingly pulled into a maelstrom fed by deep and profound identity crisis. At a time in which many standards and norms have begun to slip, many people in various stages of their lives, particularly the young, hardly know what is good and bad. Who then would wish to argue with the view that a new social consensus is needed, and at the global level, because it's precisely globalization that demands a global ethic. Global ethic demands the globalization, if it wants to remain human, asks for a global ethic. All of this is hardly possible without an ethical impulse, without ethical momentum or moral energy, as was shown, for example, in the great works, achievements of the 20th century, after all these wars, certainly the Marshall Plan. It was not only an organizational problem, it was an ethical impulse behind. The same in the development of the Universal Declaration of Human Rights, or the founding of a united Europe, which as at the beginning also was not an organizational or financial problem as it is now. Of course, regarding the Global Ethics Project, it is a question of decades, of a decade-long process of change in conscience. Just a question of women's emancipation, just as the question of women's emancipation, of ecology, and of peace in the global world was a question of a long change of conscience. We all didn't think the same way 50 years ago as we do it now. And in us, and in this process of realization, the general normative rules of the global law and global ethics will be subjected to the iron-hard test of practical experience. Thereby, what holds true as a matter of principle, universal norms always must be applied in a situation-specific manner. Norms without context are hollow. A context without norms is blind. This means norms must illuminate the situation, and vice versa, the situation must define the norms. To be morally good is thus not only what is in the abstract good or right, but what is concretely good and right. In other words, only in the particular situation does the responsibility or commitment become concrete. But in a particular situation, in which, of course, only the person affected can judge best, only in such a particular situation, the commitment can, for all intents and purposes, become absolute, unconditional, categorisch. This means our how we are to be, our Sollen, is always situational, but in a certain situation, the solon, the how we are to be, can become categorical. That means without the ifs and buts. Thus, in every concretely moral decision, global ethic thus in every concretely moral decision, one must always bind together the general normative constants to the particular situational variable. Of course, I know that judges must render binding decisions in specific cases. He or she should not and cannot base decisions on abstract terms. And the global ethic does not make the judgment of an individual case any easier. These cases could break down quite differently. First, there are any number of relatively simple cases by which positive law fully suffices for the decision and the recourse based on general legal principles or global ethic principles is unnecessary. There is positive law, such as the law of the road in traffic regulations, which has, as such, nothing to do with ethic driving on the left, or on the left side, I mean, yes, of the road. That would also be possible. It certainly could, but it can, of course, become an ethical duty because it would be an issue of life, when it becomes an issue of life and death, if you do it, if you change it. Relatively simple cases, which do not need recourse to global ethics. But there are also high complex cases, such as the stock market, trade in derivatives, pure financial competition without any real exchange of goods. The extent to which this is unethical requires a precise examination by financial experts and the application of economic law and economic ethics. If in the end it is a matter of deception and stealing, then it would be immoral. And I think the case I just quoted with Citibank is quite clear. Then the derivative market has to be banned and the offenders punished. All this means the global ethic will not offer a legal or ethical casuistry, but rather principles and guidelines for a casuistry. In fact, general legal principles already can be supported through universal ethical principles, just as they have been accepted by the representatives from all major religious traditions in the already cited Declaration towards a global ethic. I may only mention that in Chicago we avoided all pronouncement, and also in other documents on global ethic, on topics to pronounce ourselves in the name of a global ethic, in topics in which there is no unity, there is no agreement. You cannot decide the question of anti-conception, of abortion, of homosexuality, and of euthanasia just from general principles. We have not yet, I think, a uniform view of that. And so it is not an object of a global ethics declaration, cannot be an object of the global ethics declaration. And we avoided, fortunately, these 4 cases in all documents. I only would like to finally give you 2 examples where principles are reinforced through ethical principles. I take first example, the legal foundation of equitableness, equitas, in Roman and canonical law. This basic principle is a corrective to the positive norm and requires basing the appraisal of a case on a natural sense of justice and fairness, which can contribute significantly to overcoming the discrepancy between the dispensation of justice and the sense of what is right. It permits a more elastic application of the positive law, which, for example, in the area of criminal law, can have an effect either of reduction in the harshness of a penalty, or perhaps for an adolescent, or an increase in the penalty. This basic principle can be understood as a legal application and concretization of the first basic principle of human ethic, of global ethic, namely the principle of humanness, of humanity, or the humanity principle. That means every human being must be treated humanely and not inhumanely. Every human being, man or woman, rich or poor, old or young, white or colored, must be treated truly in a truly human way. Of course, the humanity principle must be more strictly defined. What does nature, more human treatment mean? In a fundamentally ethical sense, this means every person should not be treated bestially or like an animal. The catchword here is Abu Ghraib, but also gulags and concentration camps. Every human being should rather be treated humanely, that is, according to his or her human dignity and attributable basic values. For judicial praxis, this sets at least a negative constraint. Inhuman is in practice easier to define than what human is. Given the natural sense, given as examples the sexual abuse of children and adolescents, or the murder of parents, or murder of teachers and schoolmates through other youth, or the rape of women, all this, I think, is quite clear. Likewise, I do not need to explicate further that positive human treatment is not always as easily ascertained. It can be seen in the never-ending and still unresolved discussions about this, especially in the field of employment law. We need discussions in these cases. The second basic legal principle is the legal principle of bona fides, good faith. It means that a certain behavior is demanded of every person, a behavior made manifest in honest, real, and truthful people. This fundamental principle is supported by a second basic principle of the global ethic, namely the principle of mutual reciprocity of the Golden Rule. Do not do to others what you do not wish done to yourself. This Golden Rule is not no idealistic slogan or rallying cry, but an ethical guideline that itself can and should be observed even in the battle of economic competition today and in political conflicts and interest. Insofar that competitors and political adversaries should be treated as fellow human beings and not be liquidated physically in the media or otherwise. Ethical criteria in economics and politics are not suspended, and lies and deceptions are not permitted either in the banking industry or in foreign policy. This does not exclude the unavoidable compromises and pragmatic solutions that are part of real life. I have not to treat my fourth part, that global ethical principles can support general legal principles. I only gave examples you have read or you may read. First, they are, and I can conclude with the three characteristics of ethical principles, what they have as advantages. First, they are acknowledged by a broad international consensus of religious group, but of groups who are transnational and transcultural. Second, also global ethical principles are not intended as legal rights and responsibilities. Nevertheless, they have obligatory power, the power of conscience, and also sanctions of conscience. And third, several principles of global ethic are well suited as prosecutors for international legal terms. They address topics today that the processes of globalization raises. So I think I tried to elaborate what we are just at the beginning to have a conference. Global ethic is, as I said, a long-time project, and of course the implications for global law are also in a long-time perspective, but I think they are essential. Thank you.
Now, dear colleagues and friends, we have now 1 hour and 15 minutes approximately to enter into discussion of some of the issues that were presented this morning. We had the presentation of the Global Ethic Project as such by Dr. Stephan Schlensog, and then the relation of global ethic to law and policy, the first approach by Bradley Shingleton, and followed by Hans Küng's reflections on, in fact, on the same issue, but in a deepening and broadening from the philosophical point of view. There's a lot, certainly, which can be discussed. Let me just recall that the issue of the global law, the Weltrecht issue, will be presented again more in depth this afternoon. So I wonder if it might perhaps wise not to, not to take up this issue now, because we shall hear a lot about this later in the day. But otherwise, please feel free to put questions to the speakers. But what we would like also to encourage is that you here in the audience, you may also wish to, to enter discussion among yourselves, because we have really the rare privilege of having such a group of eminent experts gathered here from various disciplines. And so to further the interdisciplinary approach of this symposium, I think it would also be very, very interesting for all of us to perhaps have some discussion also among yourselves here. So may I invite questions or comments? There is also a microphone here in the hands of this lady, Karen, yeah. So you will pass it around. And otherwise there is of course also a possibility to come here. So please. Yes.
Drew Christensen from America Magazine. It's a question for Bradley Singleton. You were compressing your paper at the end, and your conclusion on Dworkin referred to the progressive realization of justice, and yet you didn't kind of expand on his underlying notion of justice as universal equal regard. And it seems to me that that ethical theory has a lot to do with with establishing an ethical basis for law, which is more than the interpretation of case law. And I'm wondering whether you'd comment on that.
Yeah, Dworkin read a really interesting paper on John Rawls and the law, and he endorses Rawls' theory of, or notion of reflective equilibrium. So in his vision, Dworkin's vision, law and justice ideally should coincide. I mean, it's a progressive process of law moving in the direction of justice. And the reflective equilibrium process comes about in that one looks at both specific laws, cases, enactments, and then moves to general principles of justice and back and forth until you find a sort of a fit. This follows with his idea of law as integrity, law as coherence. I think you're absolutely right. The moral weight of Dworkin's vision has a lot to do with how he conceives of justice. yes, he is a fan of Rawls, certainly in the sense that justice's fairness is part of the content of justice for him. I think, however, the significant point for what we're talking about here today is, and it didn't probably come out very clearly due to the compression of what I said, but justice for him is really a politically derived vision. He brackets in a number of different places in his writing religiously, sort of like Rawls with his comprehensive worldview. He doesn't really easily find a way to open the door to religiously grounded ethical contents. And so what I wanted to suggest was, well, you, Dworkin, you don't like this because you're concerned about divisiveness, about the same things that Rawls is concerned about. But consider the global ethic. I think the global ethic is not a divinely inspired document. There's all these epistemological reservations about how do you ground the religious ethic. And I think Hans Küng's version does not completely resolve all those, but certainly the hard work that he's done in trying to establish consensus based on careful scrutiny of the history and evolution of these traditions, I think goes a certain way towards reducing this anxiety about divisiveness in the public square. And so what I was trying to suggest is the global ethic could perhaps contribute to making Dworkin's notion of justice richer and more complete. Part of the problem is a political vision alone enough? I mean, that's kind of a question for the audience. I mean, are we comfortable defining community in political terms pretty much exclusively? He's, of course, talking about law, but he has a very encompassing, comprehensive view of law. So I'm just asking the question, really, how do you make room, or should there be room, for other perspectives, more comprehensive perspectives, but perspectives that at least address the concern of divisiveness and fractiousness in talking about religiously derived ethics. And that's kind of the question I was trying to open up.
So following through on that notion of divisiveness, this is directed toward Professor Küng. You mentioned the papal encyclical Humanae Vitae, in which the Pope stressed that it would be against natural law to use contraception. And what that brings up in my mind is that what Bradley is talking about, a certain resistance against considering interreligious perspectives or any religious perspectives in law or global ethics, I think has to do, to some extent, with the notion that this will be somehow the most fundamentalist or repressive aspects, that when religion is raised for many, many people who work in this field, they're making those kinds of associations. I'm aware of the context in which we're meeting, and I would also, my degree is in theology, so I would also mention, however, that this is obviously what is needed. How do you, Professor Küng, envision, first of all, working either around the complication of the force of the Catholic Church that has made addressing global phenomena like the AIDS pandemic virtually impossible to some extent and really worse, and then the whole notion of contraception. You don't even have to get into abortion, but if you just speak to those, how do you work with that complication? How do you see overcoming both those negative associations and even working directly with the Catholic Church about these entrenched notions? Thank you.
think we have to come to the basics, and that is reverence for life, and reverence especially for human life. There is no doubt about the fact that we have, from the beginning of the human being, the fertilization of a cell, we have human life. But what is disputed is that this is already a human person. And we had, until the 19th century, more or less the Küng doctrine coming from Aristotle, Thomas Aquinas, the Spanish scholastics and others, who said that we have animatio continua. It's a continual animation and not one from the beginning. And we have clear enunciations of Thomas Aquinas, who said only in natura intellectuali is a persona possible. Without an intellectual person, you do not have that. And I think this was a quite good theory, even if it was not elaborated now in terms of modern biology, but nevertheless they saw that this is a development and not just from the beginning. We have unfortunately the date of 1854. Everybody should know that this is the date of the definition of the Immaculate Conception of Mary, not of Christ, of Mary. And since this date, we have a concentration on the first moment of life, because this is bound to another very problematic theory, which I think is not found in Scripture, that is original sin. Original sin transmitted by sexual intercourse. That is the very unfortunate idea of a great genius in the theology of St. Augustine, who introduced this sexual interpretation of the book of Genesis, 3rd chapter, in the 5th chapter of the Epistle to the Romans. All there you do not find anything about sexuality, but Augustine, as a former Manichaean and a man with sexual experiences which were more and more doubtful for him, he had really not a very good attitude, not a positive attitude of sexuality. So if you combine these two things, if Mary had no original sin, then you must insist that from the beginning Mary was of course a human person. And so we got more and more the idea that you have a human person from the beginning. As a matter of fact, the practice of the Catholic Church remains the same. We never had very many problems for a burial of a fetus. Never fetuses were buried solemnly by liturgical action, because this was not considered as already a human person. And so I think we should come back to a vision which is biologically founded. I think already with the functioning of a brain in the human being, the fetus, you cannot speak of a human person, according to Thomas Aquinas, and I think that intellect is the specifically distinction of the human being from the animal realm. So I think it would be possible. But I had myself a discussion with Pope Paul VI just before the encyclical, and I saw quite clearly, and you can read it in my memoirs, the whole scenery then, that for Pope Paul, it was not a question of sexuality, it was a question of infallibility, that the whole church, that all the bishops of the world defended now the position that these, that from the beginning you have a human person, and that now artificial, so-called artificial birth control, contraception is unethical. So we are blocked in this fear. I think Pope Wojtyła and Pope Ratzinger both affirmed the theory again and again and get more and more into troubles. As a matter of fact, only maybe 10 or 50% of Catholics in the developed countries are following this doctrine, and it's not at all. And as a matter of fact, the encyclical Humane Vitae, I think my good old friend Andrew Greeley was correct by his research. Humane Vitae was, as a matter of fact, the break of the general consensus the Catholic population had with the popes. after Humane Vitae, a lot of people, even my own mother said he should not have written that. So these are the problems, I think, you see, which have to be discussed, but you cannot, I tried really everything to avoid discussion in the Parliament of the World's Religions or in the Interaction Council where Jimmy Carter was present. We had a great discussion about truthfulness in the Interaction Council with Jimmy Carter and others, but not about sexuality. As a matter of fact, Chancellor Helmut Schmidt, who wanted to convince Pope John Paul II that this is the wrong position they have in the population policy, he was not able to do it. He wanted to introduce this in the declaration of the Interaction Council, and I objected that this is wrong. We can affirm that we are for birth control, and it is a paragraph now affirming birth control, but by what method is left open. You can have it, as a matter of fact, what is also immoral according to the Roman doctrine, natural abstention. You can have Ogino Knaus method, etc., etc. So we are still in this difficult situation that we defend a theory which is undefensible.
So the next on my list is David Little, who is an expert in religions and peace issues. So perhaps this question of how to avoid that ethical rigorism informs law can be partly responded also by him. Professor Little, yeah?
Yes, thank you very much. Actually, I don't want to go, that's an important area. I wanted to address a question, I think, to Brad and to Hans Küng about the grounds of the global ethic. In his paper, Professor Küng says, as a theologian, I cannot understand why the natural world, the nature of human beings, should contain within itself a criterion or measure for determining what is morally right. So on the one hand, it looks as though nature, in some broad sense, is not the area of grounds for this global ethic. But on the other hand, I've heard in reading your paper and from your own words that it's not religiously grounded. And therefore, I'm not quite clear where the grounds of accountability might be. That is to say, what are the grounds upon which you could hold people accountable for affirming or not affirming the global ethic?
Directed to both of you, who wants to?
Very briefly, I think you are right, insisting that not nature. I do not say that we have not to observe nature, but it cannot be an unconditional norm. We have to control our eating, our drinking, and also our sexual activities. And we cannot just follow nature and drink as much as we can. So nature certainly is not possible. Religion can be for religiously motivated people. For Muslims, the Quran is of course an authority, as the New Testament for Christians. No doubt about that. But it cannot be the universal norm. So we have to see where we have an agreement in humanity about certain things. And as a matter of fact, it's a whole series of foundation. You can found global ethic, I think, also from the development, the evolution of the human race, because the human being had to learn to be human. We come from the animal world, and we were not accustomed. Animals are able to kill each other, and human beings had to learn that we are not allowed to kill other human beings as we are allowed to kill animals. That was probably the first conscious command to avoid to kill innocent people. And we had first rules for preserving the life of a person, reverence for life as a general norm, not to murder. Second, we had to preserve property. That was also very early when property was established. Even in Australia, you are not allowed to take the weapon of the other one, to steal. Not to steal, it's the preservation of property. The third is truth, to preserve the truth, sincerity, confidence is very basic for human beings and the relations between human beings. So we have not to give wrong testimonies, not to lie. And fourth, of course, sexual relations have to be protected from the beginning, and also Aborigines have very complex rules how to protect sexual relations. So we have these four things: not to kill, not to murder, not to lie, and not to abuse sexuality. So these are not just accidental topics. And here we have now, according to a process of several thousand years, 10,000 of years, we have developed now these certain rules. And in the religions, these basic rules are, of course, accepted and put under the absolute norm. The Torah of the Jews, I mean the so-called 10 Commandments, were not invented. They were already valuable before, but they were put under the supreme authority of the one true God. And it is, of course, a difference for religious people. If you say, I am God, your Lord, you shall not kill. You shall not kill, that's another kind of authority. But you cannot establish now in a secular society that everything has to be done in the name of God. That was the famous discussion we had in the European Union, whether the name of God has to be placed in the European Constitution. That was, I think, not possible. But what would have been possible is to mention clearly Judaism and Christianity as root of the human rights and roots of the whole of morality. It's not just the Enlightenment, as certain people thought from the Lysis camp. So we have a consensus among religions about these four basic demands, and we have a consensus also with non-believers, with secular people who do not want to be murdered and all these things. And so we have a practical consensus. How you found it yourself, that's up to you. We cannot prescribe the ground, what you are asking for. The ground may be different for you and for me, for others, but the content has to be the same. If we are in the same boat, it's not very important how we found our commandment of survival, but we have to survive following certain ethical standards which are basic.
So it is consensus, a consensus gentium, fundamentally.
In a way, it's a consensus gentium, but I think we see in the evolutionary development, not just as a status like this, and also consensus gentium between the religions, because we have, of course, very strong, the 10 Commandments are repeated in the New Testament. I think that's a great heritage we have from the Jewish tradition, and it is also in the Quran. So there is no doubt about these things, that in higher developments of higher culture, of so-called higher religions, we have then expressively formulated these terms as commandments of God.
Bradley, would you like to add something?
Yeah, I was going to ask David a question. Take, for example, the UN Declaration on Human Rights. What is the grounding for that?
Well, that's an open question, but there are assertions in the preamble
To the UDHR. Oh, sorry. The question was, what about the UDHR and other human rights documents? What are the grounds for that? What's interesting about the UDHR preamble is that it says certain acts have occurred during the Second World War which disregard and show contempt for the conscience of mankind, barbaric acts. It seems to me that there's an assumption, not explicated, that some moral violation has occurred. The phrase conscience of mankind seems to me clearly to assume that. Now, the best one can do is to try to figure out what the moral grounds of that are, and I won't try to give you my view of that now, but the point I would make is that that does assume that you can hold people, religious people, non-religious people, accountable for violating what are understood to be the assumed norms of the conscience of mankind. And whether or not people concede to that or agree to that is not really the question. They may or may not, but they are nevertheless held accountable. And it seems to me the whole human rights literature, as well as I would think the global ethic, implies that you can hold people accountable whether or not they happen to agree with it. The consensus part opens the question, well, I may reject it myself, and therefore am I bound by it? And I would think that a global ethic or a human rights ethic requires that some accounting be given for holding people accountable, whether they consent or not.
Well, I don't know how much it helps, but and it sounds simplistic, but I'm not aware of anybody contradicting any of the principles in the global ethic. So you could say, well, if you don't want to be held accountable, what's your problem with it? Do you have a substantive objection to it, to any of the principles, or is it, what is it? Now, Hans Küng is explicit in his book-length works on the global ethic that a religious grounding is not simply an optional necessity. In his vision, it's an integral part of his project. He's been criticized. Jean Porter criticized that position. You know, there are a number of people who have. And that is really an instantiation of the debate of the relation between religion and morality. For me, it's significant, at least looking at it from a legal point of view, that the fact of non-contradiction, the fact that you're not finding anyone objecting to it for substantive reasons. And I think that's what suggests itself to someone like a Dworkin, who may say, well, wait, that's external morality. You know, my vision talks about embedded morality within the evolution of the law itself toward moving towards justice. I don't really have room for that. I don't see a place. It doesn't cohere with the rest of what I have to say. And I'm not sure that that's the last word on it. That's why I'm suggesting maybe a broader notion of justice, which can incorporate some of these possibly extra legal considerations that nevertheless have legal relevance.
The two colleagues here, is it to the same point? Is it related also to this question of the notion of justice? And you too, sir? Yours also, or would you? No, not yours. So in this case, I would perhaps prefer to take him first, and you after.
Back there. There's a woman back there.
Very quickly, we have broad principles that we agree on. In the United States, we take those broad principles from a religious foundation. We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain inalienable rights, life, liberty, and the pursuit of happiness. Our whole problem is twofold. One, to determine what do we mean by the word men, and the second, how do we apply that broad principles to what we do in positive law? I can't answer that question, but I do think that in the United States, our total background has a religious basis. Not a sectarian religious, but a religious basis.
Are there reactions to this, still to this field of questions, or can we move ahead? Is it the same issue?
Yeah.
Okay, so I would like to take you and Sean perhaps.
I would like to follow up the discussion between the two of you and Tom Little and the question of the consensus gentium. So how do you deal with gender equality in all this field. Because what you talked about, so what's the ground of the principle? It's neither nature, it's neither law, it is the consensus gentium. How do you apply that if it comes to gender equality? You can't find it in nature. As a biblical scholar, I would say you can't find it either in the Hebrew Bible, neither in the New Testament. I'm not so good in interpreting the Quran, but I would say you can't find it there neither. So how do you bring then gender equality in this whole discussion?
Who wants to respond to this?
The fourth directive on how is it called, partnership was of course one of the two problems we had to face in Chicago, where there was more opposition than to others, because it's quite clear that for all religions, not only for Islam, for all religions, the problems of partnership and of the equality of sexes is an issue that has to do again with the whole development of humanity from the beginning, that we have, whether we had a period of matriarchy is disputed. In any case, it became clearly patriarchal. And it became clearly a patriarchal system, and more or less in all religions, with the exception of a few special Indian religions. So the Catholic Church needs a great deal of time before acknowledging certain things, especially in equality of sexes. Even the Swiss Confederation, I'm a proud Swiss citizen, but a very old democracy, probably the oldest still living in the world, had great difficulties to acknowledge equal rights. And so it is not surprising that also religions had, of course, to make a great deal of reflections. That is similar. I had a big discussion in Tehran with the leading mullahs many years ago. What about the text of the Ephesians? They said, we cannot accept now the equality of sexes, but you have also this problem. I said, yes, we have this problem. How can, it's a beautiful text, the 5th chapter of the Epistle to the Ephesians, which is often quoted in the wedding ceremony. But if you look at it, it is clearly, again, a patriarchal background of this text. Now, what we do in Christianity is to have an exegesis, to look at the purpose, the so-called scopus of the text, in order to interpret then the context in a different way than 2,000 years ago. And I saw that Muslims can be convinced of this. I asked them, you have in the Quran also a surah in which the husband is allowed to punish the wife, his wife, in 3 phases. He can even beat them. In the 3rd phase, he can even beat her. That is obviously a contradiction to human rights. How to resolve this, what they call in Islamic theology, an opposition, contradiction between revelation, the Quran, and reason, human rights. They interrupted the discussion. That was the first time. It was really the first time they interrupted the discussion and discussed among themselves. Then after they came back, the speaker said, we have a common solution. If there is a contradiction between revelation, the Holy Quran, and reason, human rights, then we have to reinterpret, we have to look again at revelation, how to interpret for today. And that is practically what we do in Christianity. And there is no other possibility. The Quran has, of course, the Muslims have more problems because they have a direct revelation in the book. We in Christianity, as everybody knows, New Testament is made by human beings, and say, I have a testimony of the Word of God, but not directly the testimony. Now in Quran, in Muslims, they have also in the 10th century, the Mutazila and so on, a very rational explication of all that. We have just to discuss it, and I think that's a major problem now, also for the Arab Spring and for the renewal of Islam, whether they will be able to interpret the Quran and per consequence also the Sharia in a way which takes up the great intentions of the Holy Book, the great demands, but interpreting it to the requisites and to the conditions of our time. If not, we have again the Sharia. If not, we have a medieval canon law, like in the law of celibacy. If not, we have also very curious Jewish customs, which are just the tradition of sin. So that's a problem for all religions.
Thank you. Now I have two people. You, sir, I think you were first already quite some time ago, the lady behind, and I see you here. So, please.
John Polakowski, Catholic Theological Union, Chicago. I have not had direct experience in dealing with the legal area, but I've had considerable experience through the religious stakeholders group in the World Economic Forum, and also the Commission on Religion and American Foreign Policy of the Council on Foreign Relations in New York. Both of these are recent efforts to introduce the perspective of religious leaders into policy decision-making. My experience generally has been that both have had a rather rocky road for two reasons. One is the internal divisions among the religious leaders. In some cases, internal divisions within people, among people who come from the same religious tradition. For example, I sat next at one session of the Religion and Foreign Policy group. I sat next to the Anglican Bishop of America, who represents the dissident Anglicans in this country, who was sitting next to a young woman priest from the Anglican Church, regular Anglican Church, and how you create that internal conversation among them. The bishop of the Anglican Church attacked me because he said the Catholic Church was not giving support to the dissident Anglicans. So that's been one problem. The other problem is that while people like the head of the World Economic Forum and Richard Haas, the head of the Council on Foreign Relations, have suddenly discovered religion as an important component, they're not quite sure what it has to contribute. And I still get the impression that what these new ventures represent is an attempt by the policymakers to impact the thinking of religious leaders rather than really creating the opportunity for religious leaders to, on an equal footing, impact policy formulation. So I just wonder if anybody on the panel can say, how do you go from some of these general principles to really making concrete policy decisions? Because that's, as we say in this country, where the rubber hits the road.
Thank you.
Maybe somebody in the audience. Yeah, Tom.
Hi, Tom Banshaw from the Berkeley Center. You've raised a whole host of issues that we'll get into in some more detail tomorrow when we look at policy issues in particular. I guess I have a somewhat more benign interpretation of why these things are so difficult, these dialogues, and I've also been part of the dialogues that you mentioned. I think it has to do with the complexity of the subject matter and the fact that it's so difficult to sort out the religious factor from the others, not just philosophy, law, economic, security interests. So I think there's a genuine puzzling going on this panel today, of course, and more generally about how the religious factor fits into discussions of ethics, whether you need religion to bring into discussions of ethics, how it fits into policy discussions. So not maybe just you didn't say this was the only reason, but you suspected there was a manipulation going on the part of political leaders trying to influence the religious sphere. I think there's a genuine puzzling going on all sides, and maybe that's something we can discuss more tomorrow.
Thank you, Tom. Now, the lady behind you.
Good morning. My name's Kathleen Caveney. I'm sorry I couldn't join you last night. I'm a professor of law and a professor of theology at the University of Notre Dame. And I want to focus on kind of a theoretical question and an intermediate level question between theory and application. In terms of the discussion about the relationship between, say, natural law on the one hand and positivism on the other, I think there's been some exciting work that's been done in the recent 10 or 15 years that really does go along with the project of trying to find some sort of middle ground. If you look at, for example, and a lot of this is out of Oxford, where Joseph Raz and Ronald Dworkin and John Finnis, three of the heirs of HLA Hart, have really dedicated most of their career to teaching. And if you read some of the recent work by Raz, by Finnis, and you will see kind of a rapprochement between the notions of natural law and positivism, recognizing the force that moral claims have on law, but also recognizing that law isn't the same thing. And I recommend two kind of articles that really embody this. There's an article called Two Concepts of Positivism. I think it's by John Gardner, who took Raz's place at Oxford, which really kind of specifies some of this. And also John Finnis has in his new collected works, 6 volumes, he's got a grand tour of legal theory where he talks about the real role played by some understanding of law as posited. And I think it's important, when we think, especially in Catholic circles about this, to maybe separate out natural law as a system of morality coming down through, kind of the manualist tradition and, focused, fortunately or not, as you see it, on sex, and natural law as kind of a grounding of some kind of common morality as a grounding for some kind of international ethic. And I think some of, if you look at Finnis's work on things other than sex, I think you find real convergences between, say, what he writes about, basic goods and the capabilities theory of somebody like Martha Nussbaum, and more rapprochement even with people like Dworkin. So I think we need to kind of maybe disentangle the sex piece, as much as I hate to see it, in looking at the grounding of law overall. That's the first thing. The second thing, as we go about trying to figure out on the mid-level how we work between general norms and specific moral principle or specific applications in particular cases, I think it's important to remember the differences in sensibilities between the common law tradition on the one hand and the civil law tradition, which is Germany and out of the Roman law code system on the other. The common law tradition really does have a sensibility, and this is my view, I teach contract law, of working between the particular cases and moving up to the level of general moral norms. And you see this operating, I think, in some of Dworkin's notion of kind of moving through the decision of particular cases up to general principles and then revising the principles and moving them back down to the particular cases. But if we're going to come up with a global law or a global ethic, I think we do have to pay some attention to the different ways different legal traditions approach norms. Is it bottom or top down or bottom up? And those will be some complexifying factors.
Thank you very much indeed. You and
I'll just respond. I agree with everything you said, and Yeah, for purposes of our discussion today, or at least for my presentation, I was engaging in a typology. I cited it as such. There are obviously a plethora of forms of positivism, ranging from hard forms to softer versions. The same applies to natural law. I selected Dworkin out of all these people out there doing jurisprudence because he seemed to really lean in both directions and against both directions at the same time. So I found him instructive. And so in terms of difference in legal systems, absolutely. Dworkin is very much a common law, his common law heritage is reflected in his thinking. There is an interesting paper, though, analyzing Dworkin's theory compared in context of the jurisprudence of the German Constitutional Court. So particularly with the idea that Dworkin is very big on, which is we should really be talking not so much about rules when we're dealing with law, but principles. And this author then looks at several of the leading cases of the Bundesverfassungsgericht and concludes that, in fact, that court is very big on principles as well. So, but both excellent complexifying points.
Before we leave the question of the global ethic and the natural law, I'd like to point out that the work of the global ethic and of Professor Küng have had an influence on the most complete and ambitious treatment of natural law by the official church, and that is the International Theological Commission's statement on natural law in 2008, I believe it was, which basically sides with the jus gentium over against the physicalist lex naturalis on the one hand, and on the other hand leans very heavily on bringing together the wisdom traditions of the world, and quotes at considerable length the work of the global ethic and Professor Küng, both in text and in footnotes. So I can't say that that kind of theoretical statement has affected particular casuistic decisions, which still seem to be made in terms of ecclesiastical positivism or the physicalist natural law, but the rendering by the Theological Commission of what natural law is today is very much in line and is drawn from the Global Ethic Project.
I didn't hear that because I'm not in this inner circle of the Roman Curia.
I didn't consult you, but I read you.
It's very hopeful, and I shall certainly study this document. You can indicate me afterwards, perhaps.
It's not published in an official translation in English, but it is in several European languages.
Thank you.
Just Stephan, yeah. Just one addition. Just one addition to this topic. We should remember the press release after the visit of Hans Küng in Castel Gandolfo. They had a 4-hour conversation together with Pope Benedict and Hans Küng, and the press release has been written by His Holiness himself, and he wrote that he supports our work on global ethic, and that has been a very good and very welcomed support for our work. That Pope Benedict himself said, okay, it's a very maybe he doesn't agree with several positions in church politics, but he agreed our work in global ethic, and maybe that's on the line what you told about the discussions you mentioned.
Well, we had just to add to that what Stephan Schlensog said, a long discussion about global ethic, and Pope Benedict, of course, said it is necessary to have common ground and moral standards. He only said at the beginning then, but he thinks that morality should be rooted in religion. Then I answered him, you know, that already in the east of Germany, which lived so many decades under an atheistic system, you do not have anymore enough people believing in God so that you can found a common ethic in religion. And the same is, of course, true for the whole Soviet bloc and for China. And he immediately agrees that, yes, of course, we have to look also for that. But in his own encyclicals, I was looking at whether he has the courage to break through. He did not have this opening. But I have the similar problem with Habermas on the left side. Jürgen Habermas also thinks that's a good idea, global ethic and so on. But according to his system, who comes out of Marxist positions, he has different problems than the Pope, but nevertheless similar problems in having problems to introduce that in his system. Because if you think, according to lines of Habermas, religion was always considered something which is, well, disappearing into the private sphere, and that reason alone is able to work this out. Now he would not anymore say this, but to integrate it positively, he has no space left for religions in his system. So it's a little same problem with the Pope, who is practically comes from the tradition of natural law, wherever anyway we generally Catholics have an easier position to accept truth outside Christianity than Protestants. If they are totally Christocentric, in a way my great friend Gebhardt was saying in his earlier period, then you have, of course, then religion as such is practically something anti-faith. He had to acknowledge in his last volume of his monumental church dogmatics that the Thelite, Jesus Christ as Thelite, does not exclude other lights. But as he told me also in private, he said, well, that's a little like if you have in the street at night a whole series of cars, one behind the other, and they have all this reflector, how you call this, cat lights of cats, we say in German.
Reflecting light.
Reflecting lights. They show their light only if they are, if they receive the light. But I said, well, that's not just, I think, what is experience. And I think a Hindu, for instance, or another person would not be happy, a Muslim certainly not be happy, if they would just be the reflection of the light of Christ. So he left this a little open.
So thank you. So this whole area of global ethic and religion, global ethic and natural law, is your contribution also to this field, or should we for the last 10 minutes open up for perhaps a last field of questions? Just let us know.
Well, I'm John Langan from Georgetown University. A couple of comments on the discussion as it's gone. One is that we have proceeded with a not terribly well-defined but rather homogenized view of religion as, in effect, one reality, and a reality positively evaluated by nearly everybody. This, I think, is unrepresentative of the culture, of a lot of the cultures in which we move and live. The historical track record of religion follows many paths and passes through some fairly discreditable territory. As we reflect backwards, we do our history so as to make ourselves comfortable in the present time. And this is something that makes it difficult for us to understand why so many people have such reservations about religion. I mean, we're drawn to, in effect, to a kind of Platonizing conception in which there's a pure and perfect ideal of religion. And often what people are thinking of, first of all, in relationship to religion is religious institutions and the embedding of religious practices in societies that often have performed quite disgracefully. And it's always, I think, useful to bear in mind something like the Christian attitudes to and practice of the institution of slavery, which almost nobody has any vested interest in protecting anymore. But this was a long struggle, and it should, I think, always be borne in mind when we think about religion as the source of moral light. I think the problem that we are confronted with, those of us who care deeply about our religious traditions, is to work out and make socially viable and institutionally viable a conception of what I would call respectful continuity as contrasted with literal fidelity. This is not, you know, I've in effect just waved two labels, but it's something that, in fact, over the years has drawn a great deal of conscientious effort by the theologians in the various traditions. But it requires a kind of candor about what's going on, which is very difficult for some religious institutions to achieve, and I think particularly here of Catholicism, but it's not an easy matter at all.
Thank you. Now on my list is Professor Kählin and you here. Is there somebody who wants to react directly to the gentleman here? No. Okay.
Walter Kählin, University of Bern. I wanted to add a few aspects to the discussion on positivism and natural law. What seems important to me is to realize how often written law, positivism, opens up, creates entry points for ethics, for natural law, for religious traditions. There was a reference made, for instance, to the language of the conscience of mankind in the Universal Declaration on Human Rights, which of course goes back to the Lieber Code, codifying the laws of war during the American Civil War. Again, a positivist list of what soldiers are not allowed to do, but then knowing, well, maybe this is not covering everything. Maybe there is immoral behavior outside, and not everything that is not covered by the written language should be allowed and permissible. In civil, continental, private law traditions, for instance, we have a prohibition of immoral contracts. They are null and void from the beginning on. Again, it's an entry point. And if you're looking at international law and at the, for instance, human rights instruments, this really, even, no, I wouldn't call it a paramount shift, but it has something of it realizing that, again, even at the international level, with all the consensus, not of everyone, but the consensus of states that in fact adopt these instruments and ratify them, we are not so sure whether we have covered everything and whether this is good enough to have that language. If you, for instance, look at the Covenant on Civil and Political Rights, it's quite interesting to see how often there is language that really provides these entry points for ethical considerations. There's the right to the inherent right of life. So what is inherent? It brings us back to when does human life start? There is a language, of course, not only of the prohibition of torture, but of inhuman and degrading treatment. Article 10 speaks about conditions for people deprived of their liberty, and it uses the notion of the dignity of the human person. The limitation clauses speak about the possibility for the state to limit human rights in order to protect morals, public morals. Again, it's an ethic notion. So I think if you're just looking at actual law, maybe always, but in any case today we have overcome this dichotomy between positivism and natural law, because we have inserted these open natural law norms into the positivist language. And going back to Dworkin and Hart, all these entry points for ethic, they are formulated as principles, not as rules. The important distinction Hart and Dworkin make: principles giving a very general directions, and the rules telling exactly how to apply. Principles saying prison conditions have to be human. The rule then saying for each prisoner you need at least 3 square meters of space, not to have an overcrowded situation. And this going back and forth between the principles and the rules, in fact, allows judges, allows lawyers to bring in a lot of the considerations we are talking here. And of course, one source, not the exclusive source, but one source can be religious traditions. And then we, of course, are getting back to the problem: which religious traditions and what kind of a reading of these texts?
Yeah, let me just respond. That's one of the reasons why Dworkin likes to think in terms of principles and not rules, because rules, if you have 2 rules, then you've got a problem. But principles inherently are open to adjustment, negotiation, and coherence.
You, sir, and the last would be Professor Kotsura. I think. I think we have to finish.
Yeah, yeah. 2 more, right?
I am Aziz Sachadina from University of Virginia and University of Toronto. I wanted to share the concern that I have in search of the global ethics that we are trying to understand this morning. I think we are in search of a paradigm that could speak across cultures and across traditions. And that paradigm can only emerge if the grounds are clarified. The grounds for the religious ethics in Islamic tradition are actually based on the revelation, and they lead us to what we call an ideal human action plan based on obedience to God. Whereas Aristotelian ethics would demand that the paradigm should be constructed towards the telos, towards the end of human life. And then we are trying to talk across traditions when the traditions themselves are pluralistic. And Islamic tradition, therefore, I think that not only in the foreign discussions in the Foreign Relations Council in New York, we don't hear a voice that is coming from one particular tradition as a unified voice, but we are talking about voices. And those voices are really not the same. And I think if I were to say here that I represent Islamic tradition and I speak on behalf of the Islamic tradition as a whole, then I'm just bluffing, because that's not true at all. I'm part of one of the voices. And that voice also is actually forbidden voice, because there's a fatwa against me. I can't speak in public. So there are certain things that I want us to be aware of, that in search of the global ethics, not only are we searching for a common ground, just as in human rights, we are trying to do that the same thing. Because one of the ways of influencing the religious communities is to get them on the board. And how do we get them on the board when there are essential differences? Not only the cultural appreciation, but the cultural appropriation of the norms that you and I think are so natural. One of the troubling areas is religion itself. You and I are laboring under the Western conception of religion, the way you and I understand what religion is all about. But that's not the way Near Easterners do. That's not the way the Chinese do. That's not the way others are doing. Therefore, when we talk that paradigm, our paradigm is very much elitist, and it is part of our world in which we operate. Whereas what we need to find in global ethics, and in order for the international law to become the law of international community rather than a law that prevents conflicts in the international relations, we need to move towards the conception of the vision of a community. And that's what global ethics needs to do in partnership with religion, not avoiding religion, but rather getting pluralistic religion on board for us to be able to have any kind of impact in the world today. Today, I think the world is torn with some kind of fundamentalism. And that fundamentalism is so extremist that you can go and talk to people in Cairo and Damascus and other places, and they would tell you about extremist voluntarist ethics, which is determined by God's command. No human reason is allowed to function as a source of human decision making. And I think we are in search of a paradigm whereby we can begin a dialogue with other religions, with other communities, and in the world at large. And I don't think there's one Sharia that we're talking about. There's not one Quran we're talking about. We're talking about pluralistic interpretations of the Sharia. Is Alistair McIntyre's question, which tradition? Whose tradition are we talking about? So when I want us to be very cautious when we mention other religions, and we cannot generalize them because there's no one voice coming like Catholic Church voice in the Muslim world today. Saudi Arabia does not represent anyone in the Muslim world.
Could you just
we still are hearing the conversation. What I want us to be aware of here is that if it is a global program,
I think your point was well taken. I think of the inner diversity of religion. Thank you very much. I think I want to, before closing the session, I would give the floor to
Thank you very much.
Sorry, would you like to
short answer?
Okay.
Sorry. I agree with you totally, because that's the reason why the Parliament of the World Religion, the Declaration of the Parliament, is called Declaration Toward a Global Ethic. That's not the global ethic they have there, you know. That's a starting point. They understand themselves. The declaration is a starting point of a process, maybe towards a new paradigm of dialogue, of understanding. And what we are doing in our foundation is that we're talking with different people in the world and in different religions, and we ask for their contribution to a global ethic. It's a process, you know. And we are talking, and that's the reason why we're talking. We have a seminar, a symposium like this, to ask which role can play ethical standards in our life, in our law, in our politics, etc. But it's a process, and it's a process you only can do with people of goodwill. You know, you can't force, for example, a fundamentalist to say, okay, I have the only one right interpretation of Quran or Sharia. With those people, you can't have those discussions, no fruitful discussions. Maybe you have, but global ethics is a project, an open project, and that's a reason why we are doing such symposium like here.
Could imagine that some of the concerns you raised, Mr. Sajidina, and you also, Stephan, may come up in the afternoon when Professor Kotsu will speak about conflicts among religions and global law. Perhaps this may enter. Professor Kotsu, I would like to close the session with your intervention.
Thank you very much. Only a very brief remark regarding our discussion on common grounds of natural law and positive law. I think Professor Kalin mentioned that we are overcoming the dichotomy of positive law and natural law because there are so many entries now of natural law philosophy into the world of positive law. I think there is another basis for common ground that also has been emphasized in German legal philosophy. Both natural law and positive law are actually cultural reflections. What we describe as natural law is very reflective. It's the way we, from a cultural point of view, describe nature, see what is kind of, you know, made clear by natural law, but it's not a kind from a epistemological point of view that we just disclose something which is there. We make a theory, it's cultural reflection about something, and that cultural reflection, of course, is open to discourse, and it's a process as you described it. And the same is true for positive law. It's also a cultural reflection on something, and the outcome is written down in treaties, in rules, in legal principles, whatever. And I think that might be a common basis. In Germany, there has been the radical thesis there is no such thing as natural law. Natural law is also cultural reflections on basic principles that we see in nature, others see it in other kind of societal formations. I think that's a very important point, and that might be something we also need for our discussion in the afternoon. It's about an open process of cultural reflections, and the more of the reflections we can share, the more we can have an open ground for a global discourse on the global ethics. Thank you.
Thank you very much. Thank you very much, Professor Kotzur. You led us already towards the afternoon, and I think that was a good contribution to close our morning session. I want to thank the speakers very much, Professor Hans Küng, Bradley Shingleton, Stephan Schlensog. Thank you very much for the precious contributions, and all of you for this very interesting discussion. Now, in the afternoon, the session will be moderated by two ladies, Professor Rebecca D. Winter and Professor Kathleen Kawain. And we now break for lunch. Lunch is here in the room, I was told, so it's just there. It's a kind of self-service. And we reconvene after lunch at 1:30. So thank you very much. See you later.